If you are a U.S. citizen, a green card holder, or you have a pending immigration case, especially if you are 65 or older, I want you to stay with me. I'm your host, and this is Immigration Updates Hub. In this video, I'm going to calmly explain what is really happening with these so-called new senior citizenship rules, who is and is not affected, and what you should realistically do right now so you can feel informed instead of afraid. Over the past few days and weeks, many of you have been seeing headlines and social media posts that sound alarming. Things like new citizenship rules for seniors, changes to accommodations, or scary words like denaturalization thrown around without explanation. Some of you wrote to me saying your heart started racing, some of you said you couldn't sleep. Others quietly wondered, after all these years, is my status still safe? So, I want to start by setting the foundation as clearly as possible, in simple language you can hold on to. There has been no sudden rule that strips seniors of citizenship. There has been no broad new law passed that targets older immigrants. There has been no announcement that people over a certain age are automatically at risk just because of their age. That is not what is happening. What has happened is much more limited and technical. Immigration authorities have issued or updated internal guidance about how officers should review and document certain parts of the naturalization process, especially when it comes to age-based and disability-based accommodations that already existed. In other words, this is about procedures and consistency, not about removing your rights. But here is the problem. Social media does not reward calm and accuracy. It rewards urgency and fear. A post that says new senior citizenship rule spreads fast. A post that says internal procedural clarification about verifying existing accommodations does not. As a result, something fairly technical gets turned into something that sounds like a major threat. And when you combine that with the very personal nature of immigration, it can feel overwhelming very quickly. If you are over 60 or 65, you have probably spent decades building a life in the United States. You worked here, you paid taxes, you raised children or helped raise grandchildren. You supported your community, your church, your mosque, your temple, your neighbors. You followed complex rules, even when they were confusing. So when you see words like rule change, your brain does not think about paperwork. It jumps straight to worst-case scenarios. Can they take away my status? Did I do something wrong without realizing it? Is everything I built at risk? That reaction is not weakness, it is human. Your immigration status is not an abstract concept. It touches where you live, who you live with, your health care, your benefits, your ability to travel, your feeling of belonging. When any of that feels threatened, even indirectly, your body reacts with fear. Social media then pours gasoline on that fear. My goal in this video is to pour water on it, not by ignoring it, but by answering it with facts and context. So let's talk about what actually changed. Recently, immigration authorities updated internal instructions to officers. Think of it as a detailed how to do your job manual about how to verify whether someone qualifies for certain accommodations in the naturalization process. These include the age-based breaks for the English and civics tests and also disability-based exceptions. None of these accommodations are new. They have existed for years and they still exist. What the guidance emphasizes is that officers should carefully check the documents and dates to make sure the person really qualifies, and they should clearly document that in the file. For example, if you are claiming an age-based exemption from the English test, the officer is supposed to check your date of birth, the resident since date on your green card, and your immigration history to be sure you have held lawful permanent resident status for the required number of years. That requirement was always there. What is being reinforced is the need for consistent, careful review and clear notes about why you do or don't qualify for that accommodation. This is important, so let me say it plainly. This is about how officers review applications, not about taking accommodations away from seniors. To understand why this matters, let's quickly remember what those senior accommodations actually are. Under U.S. law, a green card holder who applies for naturalization normally has to show basic English ability and pass a civics test about U.S. history and government. However, there are special rules for older applicants who have been permanent residents for a long time. If you are 50 years old or older and you have been a lawful permanent resident for at least 20 years, you can usually be excused from the English language requirement. You still have to take the civics test, but you can take it in your own language with the help of an interpreter that you bring. There is a similar rule for people who are 55 or older and have been permanent residents for at least 15 years. Again, you may not have to take the test in English, but you still answer the civics questions in your language. with an interpreter. Then there is a special rule for seniors 65 and older who have held a green card for at least 20 years. In that situation, you may not have to take the English test, and you also get a simplified version of the civics test. Instead of needing to study the entire larger list of questions, you are tested on a smaller, specially selected set of questions designed for older applicants. You still have to answer correctly, but the list is more focused, recognizing the reality that learning a new language and memorizing large amounts of information can be more difficult with age. On top of these age-based accommodations, there is also something called a disability exception. If you have certain medical conditions, for example, serious memory problems, cognitive decline, or other conditions that make it impossible for you to learn English and/or US civics, a doctor, a clinical psychologist, or another qualified medical professional can complete a form that explains this. If U.S. Citizenship and Immigration Services accepts that form, you can be excused from one or both parts of the test, depending on your condition. Again, this is not new. These tools have been part of the system for years. So what is happening now is not that these age-based and disability-based accommodations are suddenly being closed off. Instead, the guidance is basically reminding officers, when someone claims one of these exceptions, make sure the dates and facts support it, and explain your decision clearly in the record. That's it. But when that kind of technical reminder gets simplified online into new rules for seniors, it sounds like the government is suddenly changing who can or cannot become a citizen, and that is not an accurate reflection of what is going on. Now, here is a part I really want you to hear carefully, especially if you are already a U.S. citizen. If you are already a citizen, whether you were born in the United States or you naturalized and took the oath years ago, these procedural updates to how officers review new applications do not change your status. They do not reopen your old case. They do not undo your oath. They do not put you under review just because you are now over 65 or 70 or 80. Citizenship, once granted, is not something that is casually revisited. Can citizenship ever be taken away? Very rarely, through a legal process called denaturalization, but that is not an interview. That is not a routine file review. That is a serious court case where the government has to prove, in front of a federal judge, that a person intentionally committed serious fraud or lied about very important facts to get citizenship, or that they were involved in extreme conduct such as war crimes or terrorism. It is not about small mistakes. It is not triggered by turning 70 or 80. It is not caused by new internal guidance reminding officers to double-check birth dates and green card dates in current applications. Unfortunately, the word denaturalization gets thrown around on social media as if it were a simple switch the government can flip. That is not how it works. It is extremely rare. It is highly targeted. It is based on strong evidence of intentional, serious wrongdoing. And nothing about these recent procedural updates has suddenly lowered that bar or created a new path to strip senior citizens of their status. Let's also separate another pair of ideas that get mixed up and cause a lot of fear: innocent mistakes versus intentional fraud. The immigration system for a long time has recognized that people forget things, people make typos, people misunderstand a question. Writing the wrong year for a job you had 30 years ago, forgetting the exact date of a short trip you took 12 years ago, mixing up a month and a day on a form, these are the kinds of errors that almost everyone makes at some point in their life, and especially when they are older and dealing with complicated histories. When officers find minor errors like that, the usual response is to ask questions at the interview, or sometimes send a written request for more evidence, so you can clarify or correct. That is normal. That is built into the process. It is fundamentally different from fraud. Fraud means you know the truth, and you deliberately write something else in order to get an immigration benefit you do not truly qualify for. That might mean hiding a serious criminal record, using a false identity, pretending you've never been deported before when you have, or lying about whether you are still married to the U.S. citizen who sponsored you when you are actually divorced and living apart. Those are conscious, intentional lies about big, important facts. The system treats those two things, mistakes and fraud, very differently. That has always been the case and remains the case now. So, when you hear that officers are taking a closer look at dates or documents for senior accommodations, that does not mean that every small error has suddenly become life-threatening. It means officers are being reminded to separate honest errors from situations where the facts really do not match what the person claims. Now, who do these procedural clarifications actually affect in practice? They primarily affect people who are currently in the process of applying for naturalization or planning to apply soon, especially those using age-based exemptions or disability-based exceptions. If you are a green card holder, over 50, and you are applying for citizenship and claiming that you qualify to skip the English test, the officer will need to check that you really meet the age and years as a resident requirement. If you are over 65 and have been a permanent resident for 20 years, and you want to use the simplified civics test, again, the officer will verify the dates carefully and record that you qualify. If you are using a disability form to waive tests, the officer will make sure the form is properly completed and consistent with the rest of your file. That is where the closer review comes in. But if you are already a citizen, or you are a green card holder who is not applying yet, there is nothing in this guidance that suddenly turns you into a target. There is no hidden line in the policy that says, reopen all old senior cases. It is about current and future applications and about how officers handle them. For those of you who are seniors or long-term residents thinking about applying, let's talk about what you can realistically do to feel prepared and protected. First, organize your documents. Having your paperwork in order does not mean you did something wrong. It means you are ready. Put your green card, your passports, your arrival records if you have them, and any old immigration approval notices together in one safe place. If you already are a citizen, keep your naturalization certificate safe and make copies. If you ever had any encounters with the criminal system, even something you think of as minor, gather the court records so that, if you ever need to explain something, you are not scrambling at the last minute. Second, make sure your address with immigration is up to date if you have an ongoing case. One of the most painful, unnecessary sources of stress I see is people missing important notices simply because they moved and did not update their address. That has nothing to do with age accommodations. It is just about communication. Updating your address takes a few minutes, but it can save you months of worry. Third, if you have a naturalization interview coming up, preparation does not have to mean panic. Reread your application so you remember what you wrote. If you notice a mistake now, do not hide it. Be prepared to explain it honestly at the interview. Study the civics material that applies to you. If you qualify for the 6520 accommodation, make sure you are using the reduced list of questions that USCIS designates for older applicants. If you qualify for the 5020 or 5515 English exemptions, remember that you still need to answer civics questions, but you can do that in your own language with an interpreter. If you are bringing an interpreter, make sure they bring a valid ID and understand that their job is to interpret exactly what is said, not to answer for you. At the interview, arrive on time, bring your documents, and answer truthfully. If you do not remember something, it is better to say, "I do not remember exactly, but here is what I recall," than to guess wildly. Officers know people can forget, especially about events from many years ago. They are trained to follow structured steps. Their job is to see if you meet the legal requirements and to document their decision clearly, not to trap you with tricks. Let's also acknowledge that waiting is hard. Many people, especially seniors, get extremely anxious when their case seems to be taking too long. But long processing times by themselves do not automatically mean something is wrong. Sometimes your local office simply has many cases. Sometimes background checks take longer. Sometimes there is internal backlog. If your case is still within the normal processing time range shown on the USCIS website for your office, the best option is often patience. If your case is far outside normal times, there are official ways to ask what is going on. You or your lawyer can submit an inquiry to USCIS, call their contact center, or in some cases, ask your local congressperson's office to check on your case. These are established channels. Used properly, they do not harm your case. Another area that many seniors worry about is travel and continuous residence. If you are a green card holder, not yet a citizen, long trips outside the United States can affect your future ability to naturalize. In general, absences of more than 6 months can raise questions about whether you truly maintained continuous residence. Absences of a year or more can break continuous residence for naturalization purposes, unless very specific conditions are met. For older immigrants who need to spend time abroad to care for relatives, address family emergencies, or deal with health issues, this can be stressful. In those situations, if you are eligible for citizenship, it can sometimes make sense to apply before a long trip, or to talk to a qualified immigration attorney about re-entry permits and how travel might affect your plans. Again, that is planning, not panic. I also want to touch on how to protect yourself from misinformation. In today's online world, anybody can post a video or a message and call it immigration news. Some of those people mean well but are confused. Others are trying to get attention or business through fear. As you listen to different voices, ask yourself, does this person explain where their information comes from? Do they reference official sources like USCIS, the Department of Homeland Security, or actual legal changes? Or do they just repeat dramatic words without context? It is also important to be careful with unlicensed notarios or consultants who are not authorized to give legal advice but act as if they are. A real immigration attorney is licensed by a state bar. Accredited representatives are authorized and supervised by the Department of Justice and usually work with recognized nonprofit organizations. They can explain your specific situation, not just give generic fear-based commentary. Here on Immigration Updates Hub, my goal is to give you clear, calm explanations of what is actually happening, so even if you later decide to consult a professional, you walk into that conversation informed and empowered. Let me take a moment to speak directly to you if you are a senior who has been losing sleep over all of this. You may have come to this country decades ago with a suitcase and a dream. You may have worked in jobs that were not easy, in a language that was not your first, to build a stable life for your children and grandchildren. You may sometimes feel that the system is cold or confusing or that policy changes are happening above your head, but your presence here is not as fragile as social media sometimes makes it sound. The very fact that there are age-based accommodations in the law is a recognition that older immigrants matter, that the system should take into account real human limitations, and that it is reasonable to ease certain requirements after many years of lawful residence. These accommodations are not a favor someone is doing for you that can be taken away on a whim. They are part of the legal framework. The recent updates we have been talking about are about making sure those existing rules are applied correctly, not about shutting the door on seniors. So let's bring everything together in one place. The updates that caused all this noise are about internal procedures. In plain words, instructions to officers on how to do their jobs more consistently. They emphasize verifying age, dates of permanent residence, and eligibility for accommodations. They do not announce a campaign to remove citizenship from seniors. They do not say that older green card holders are now unwelcome. The age-based 50-20, 55-15, and 65-20 rules still exist. Disability exemptions still exist. If you are already a citizen and you obtained your citizenship in good faith, these updates do not secretly place you in danger. Denaturalization remains extremely rare, court-based, and focused on serious, intentional fraud, not on small mistakes or getting older. The immigration system still distinguishes between human error and deliberate lies. What you can do, starting today, is straightforward. Get your documents organized, make sure your address is current if you have an open case, prepare calmly if you have an interview coming up, and seek qualified help if your situation is complicated or if you have a long or unusual history. Understand that delays often reflect workload, not a judgment about your worth or your future. And remember that feeling fear does not mean you are in danger. It means you care deeply about the life you have built. If this explanation has helped you feel more grounded and less afraid, consider sharing it with a parent, grandparent, neighbor, or friend who might also be worried right now. Staying informed with accurate, calm information is one of the best forms of self-protection in a noisy world. On this channel, Immigration Updates Hub, I will continue to break down changes and clarifications in a way that respects both the legal details and the human emotions involved. You have invested so much into your life here. You deserve clarity, not confusion. You deserve calm, not panic. Take a breath, stay informed, and take things one step at a time. Can seniors lose U.S. citizenship under new 2025 immigration rules? Is USCIS targeting naturalized citizens for denaturalization? Are green card holders over 65 suddenly at risk? These questions are keeping thousands of immigrants awake at night right now because of terrifying headlines spreading online. You are watching Immigration Updates Hub, and I am going to answer every single one of these questions with facts, not fear.